Great. Welcome to the Disability Rights and Resources Summit. My name is Rachel Loria. I'm going to be moderating this session. I'm going to start by just a couple of housekeeping notes. If you need to access live transcriptions, please go where it says live transcript and hit show subtitles. We're also glad to answer any questions after the presenters have finished presenting their information, but you can submit your questions anytime using the chat feature. So I'm going to introduce our presenters. Zachary DeVore is a senior staff attorney with the Disability Law Center of Virginia. Mr. DeVore has been an attorney with dLCV since 2007. He's a graduate of William and Mary Law School. At dLCV, Mr. DeVore represents clients in Americans with Disabilities Act cases, including effective communication and other accommodations within medical offices. Stephen Traubert is the litigation director for the Disability Law Center of Virginia. dLCV is the designated protection and advocacy agency for the Commonwealth of Virginia. Federal and state laws invest dLCV with unique and extensive authority to advocate on behalf of individuals with developmental and other disabilities, including the authority to pursue legal, administrative, and other appropriate remedies or approaches to ensure the protection of and advocacy for the rights of people with disabilities. As the P&A agency for Virginia, dLCV has a strong interest in enforcement of the Americans with Disabilities Act, the ADA, to assure full inclusion of people with disabilities. Stephen obtained his Bachelor of Arts degree from the University of Notre Dame and his Doctor of Jurisprudence from the West Virginia University College of Law. Prior to joining the Disability Law Center, Stephen practiced in a variety of legal fields, including poverty law, housing, family law, consumer protection, personal injury, business law, and a variety of other areas. He's practiced in Ohio and Virginia and is admitted to all state courts in Virginia, as well as the Federal District Court for the Eastern and Western Districts, the Bankruptcy Court for the Eastern District of Virginia, the Fourth Circuit of Court of Appeals, and the Supreme Court for the United States of America. And our last presenter, Karen Brim, serves as the Interpreter Services Manager for the Virginia Department for the Deaf and Hard of Hearing. Karen has several degrees related to interpreting, including Associate of Science in ASL Deaf Studies and the Associate of Applied Science in ASL English Interpretation, completed in 2011 at Reynolds Community College in Virginia. As a Bachelor of Service from Interpreter Training at Troy University in Alabama, completed in 2014, and a Master's of Art in Interpreting Studies and Communication Equity, completed in 2018 at St. Catherine's University in Minnesota. She has the Education K-12 Specialization credential from the Registry of Interpreters for the Deaf, RID, and VQAS 3. She was an interpreter at the Chesterfield County Public Schools during the 2012 to 2019 years, and also worked as a community and video interpreter with Purple Communications during 2014 to 2019. She's been an adjunct instructor for the interpreter training program at Reynolds Community College since December 2013. She's joined VDDHH in 2019 as the Community Services Manager, managing the Information and Referral, Education and Training, and Outreach Services Unit, and representing VDDHH as the liaison on some state work groups and committees. When the COVID-19 pandemic started, the Virginia Department of Emergency Management, VDEM, asked her to serve as the acting Access and Functional Needs Officer to assist with the Commonwealth's response to the pandemic. Her statewide efforts have heightened awareness of the accessibility needs of all people with disabilities, including those who are deaf and hard of hearing. So we want to thank everybody for presenting today and let them take it away.
Thank you, Rachel. Very much appreciate your introduction. I'm going to go ahead and make a few sort of preliminary comments. Again, my name's Steve Traubert. Hopefully you're starting to see our PowerPoint on your screen. So far, so good. What we're going to do is we're just going to give a little bit of an overview about some of the laws that are really important to understand about interpreters and accessing information in general. And then we're going to talk about how to access those services. Karen's been kind enough to join us today to really talk about what that looks like when you need that interpreter and how you go about requesting that interpreter. Then we're going to try to explain how these interpreter rights apply in different settings. So Zach's going to start out talking about healthcare a little bit, then we're going to move on into education and legal settings. We have about an hour for the presentation today, and with a relatively small group, we want to make sure that we're answering the questions that you may have. So please feel free to post your questions using chat at any time. We're probably going to wait until the end to answer those questions, but it may not be a bad idea for you to go ahead and post them while they're fresh in your mind, and we'll make sure that we have time at the end to resolve those. So it looks like the screen sharing is working the way it's supposed to, always a little bit of a concern. And with a little luck, the PowerPoint will progress as it's supposed to. So let me see if I can get that started here now. And one of the things that's important to understand for those of you who aren't familiar with us, the Disability Law Center, is that we are established as a protection and advocacy organization. And what that does is that gives us unique, not only authority to advocate on behalf of individuals with disabilities, but also the responsibility to do so. And so one of the things that's important to us when we do a presentation or training like this is to make sure that we're getting feedback and we're learning about the types of problems that people are dealing with. So if during this presentation you say, well, I've tried to do that and it didn't work for me, or I have this question, or I have this area of frustration, I think not only would Zach and I like to hear about that on behalf of the Disability Law Center, but I'm sure Karen would appreciate that feedback as well on behalf of her agency, which is the Virginia Department for the Deaf and Hard of Hearing. Karen, I stole this from your website, so I hope I'm not misrepresenting what you guys are doing over there. But they do a lot more than just provide interpreter services. That's one of the services that they provide. But they really do, as Karen's bio alluded to, do a lot of things to try to make sure that these programs, services, and opportunities are available for full participation throughout the Commonwealth. All right, so I always think it's important to mention these recent disability statistics, because a lot of times when we think about people with disabilities, we try to imagine this small group of outliers, this small percentage of people for whom all this attention is being paid. But the reality is it's a huge number of people, roughly 1 out of 8 people in the United States, and about that same number of non-institutionalized Virginians are people with disabilities. Now, that doesn't mean they're all going to need interpreter services. And of course, it doesn't mean they're all going to need the same accommodations. But I think looking at that number and realizing that this is not a tiny few people for whom we're trying to change things or open up the world a little bit. We're really looking at a very large number of people who require these types of accommodations that we look for, require the types of services that we're going to talk about today, and trying to make sure that people know what rights they have, and also at the same time understand the obligations that the courts might have, that the schools might have, and that the different places of public accommodations, like Zach's going to talk about with medical offices, they have. This isn't something that is a new obligation. It's not some burdensome thing. It's just meant to sort of give access to services to this large number of people who may not have it otherwise. So today we're going to talk about the disability law overview a little bit. Zach's going to talk about where these rights to interpreter services come from, specifically medical settings. Karen's going to fill us in a little bit on how to request those services and how that works. And then I'm going to come back and talk about some of the educational settings and legal settings where these issues often come up. And then at the end, we'll have time for some questions. So please, again, if you have questions that pop into your head based on something that we say, please go ahead and post that question in chat, and we'll make sure then that we have time at the end to answer all of those questions. All right, so Zach and Karen, I'll probably be able to tell when you're done with the slide, but just go ahead and say next slide, and that way I'll be sure to make sure that we're all on the right page.
Yes, hello. I am Zachary DeVore, one of the attorneys here at dLCV, and I am going to talk about healthcare settings and start out with kind of an overview of the law, because there are three federal laws that impact the healthcare and they also cover a lot of, and two of them also cover other settings besides healthcare. The first is the Americans with Disabilities Act. Title II covers state and local governments. In Virginia, the CSBs qualify as being a state and local government, and some public hospitals, some public health centers would also qualify. And Title III is places of public accommodation. This should cover just about everything else within the medical field. That would include your private hospitals, your doctor's offices. Now, another law which is very important is Section 504 of the Rehabilitation Act. And this act covers recipients of federal funding. And that should include participants in Medicare and the Medicaid program. However, and that would be, for example, if a doctor's office receives funding from Medicare or Medicaid, they should be covered by the Rehabilitation Act. Now, I say should because that's not, even though the law's been around since 1973, that's actually not been definitively stated by the federal courts. The third law only covers Section 1557, only covers healthcare settings, and this is Section 1557 of the Affordable Care Act. This one is also particularly important if you're looking at effective communication for something other than disability accommodation, because Section 1557 also protects the rights of people with limited English proficiency. And this covers recipients of funding for the Department of Health and Human Services. And it also covers the experience exchanges created under the Affordable Care Act. And as you can see, there's a lot of overlap with the Rehabilitation Act in 1973. So most providers would be covered by both. Next slide, please. There's also a state law, which is the Virginia with Disabilities Act. And there's some information about the Virginia with Disabilities Act on your screen, which shows the different sections. However, for our purposes, the Virginia with Disabilities Act is really the state version of both the Rehabilitation Act because it includes recipients of state funding, and also the Americans with Disabilities Act because it covers places of public accommodation. Next slide, please. And then with the four laws, you really, one of the questions you might have is, well, what do you use? If you're going to, for example, a doctor's appointment, what law would you actually cite? Would you go out there because a private hospital, for example, would be covered by the Americans with Disabilities Act, Virginians with Disabilities Act, Section 504, and Section 1557. But which law would you request it under? And if it's for disability accommodation, you'd use the ADA. Now, if you're requesting a different language interpretation, you would probably want to cite Section 1557. But the reason why you use the ADA is because it has the best developed regulations, it has the best developed case law, it's the most famous. You also have some guidance you can also use because the United States Department of Justice, who issues the regulations for the ADA, has produced an excellent guide for effective communication. And this is something you can actually present to providers because it includes some specific examples for when interpretation might be needed and it provides specific examples of what auxiliary aids and services are. And between Title II and Title III should cover most every healthcare setting. Next slide, please. Now, with the ADA effective communication requirements, these are actually different depending on what kind of setting you're on. If you have a state or local government agency under Title II, the regulation states a public entity shall take appropriate steps to assure the communications with applicants, participants, and members of the public and companions with disabilities are as effective as communications with others. As you can see, this is a very, very strong protection. Title III is much longer. And because it's much longer, I'm not going to read it to you just because it takes up quite a bit. But it says a public accommodation shall take those steps that may be necessary. And you can see it as a very big difference between shall and may, because the protections under effective communication are much stronger if it's a Title II entity than it is if it's a Title III entity. Next slide, please. Now, of course, you look at the regulation and you see auxiliary aids and services. What is an auxiliary aid and service? And the answer is it's pretty much anything that enables a person with disabilities to communicate or receive information effectively. It is very important to note that it includes both expressive and receptive communication. And the regulation lists several examples of auxiliary aids and services. This is just a sample of them because these are some of them that you might see more often. First is interpreter, whether in person or through video remote interpretation. The second one for people who are hard of hearing is assisted living devices or systems. It also can include note takers or exchange of written notes. So if you pass notes back and forth, that actually can be auxiliary aid and service. And it can also include some for providing information. For example, if you have a video message system, an example would be if you're at the airport and you have a list and you see like what the flight is and what time the flight's departing, that would be an example of a video message system. And then you can also have for receiving information for people who are blind or have low vision, and that includes qualified readers, film material, audio material, and in fact, including anything else that provides for effective communication. So really, it's a very expansive definition as anything that includes anything else at the end. Next slide, please. Now, again, with the requirements to provide effective communication, it's important to determine what kind of entity you're with. If you're with a state and local government, it shall furnish whenever necessary. If it's Title III, and in fact, generally that means that the state and local government should provide the service which is actually requested. Now the third one is, now under Title III of Public Accommodations, it's the public accommodation should consult with a person with a disability about what their preferred accommodation is. However, the private entity has the ultimate authority to decide which accommodation to provide. If you are a person who requires an interpreter and you prefer in-person interpretation, the private entity can say, we are not going to provide in-person interpretation, but we will instead provide video remote interpretation. And as long as that is effective, that is okay under the ADA. It doesn't matter if it's the precise interpretation they want. Now, in both cases, the type of auxiliary aid and service required will vary based upon factors including the lengths, nature, and complexity of the conversation and the context where it is taking place. For example, if you have a very complex, very important conversation, which almost everything in a healthcare variety would qualify, it allows for much more expensive auxiliary aid and services than it would if it was a short conversation. If you're ordering from a restaurant, chances are good that a picture menu where you just point to what you want is probably complies with the ADA. Now, if you are going to have a trial in court, that would not be sufficient. Or if you're going to go out there and confer with your doctor, that's probably, again, a picture pointing to something is probably not sufficient. And there's also the requirements which are both must be timely, effective, and protect the privacy of the person with disabilities to the same extent possible as others. And that is particularly important in a medical setting where in the medical offices, of course, any conversation you have with your doctor is protected by privacy rights. And in that case, the interpreter would would go out there and be covered by the privacy protections. Next slide, please. Can I get to next slide?
It might be showing the next slide, Zach.
Okay.
Companions and family members.
Yeah, that should be the next one.
Can someone else who's in the room let us know which slide you're seeing right now?
I'm still seeing the requirements to provide auxiliary aids and services. Oh, now it's up. Okay.
All right, thank you.
Now, with one of the things you hear a lot about, and in fact, this is a call we get very frequently from persons calling the dLCV, is the public entity, for example, a doctor's office, once, for example, if you have a husband who is deaf and a wife speaks both English and sign language, they want the wife to interpret. According to the ADA, that's not under either Title II or Title III, that is not supposed to happen. Neither a Title III nor a Title III entity can require somebody as a family member or other companion as an interpreter or bring another person to interpret for them. But there are two exceptions to this. The first one is one that primarily comes up in the healthcare setting. It can come up in a few other settings, but primarily this is based on healthcare. And that's an emergency situation where there's an imminent threat to life or safety of an individual with disabilities and no interpreter is available. And this one actually can include using a child as an interpreter. And that's because, you know, in this case, it is something where it would be very urgent because it is only emergency, and they mean only emergency. The second situation is a person with a disability can actually request that an adult serve as an interpreter if they're not, but the other individual must also agree to serve as the interpreter and that reliance on the person is appropriate. So if they say, I want my friend to interpret, and a friend says, oh, I actually can interpret, then they cannot require that person. But this really kind of gives the right to say, you know, you have the right to an interpreter, but if you want your trusted friend, you want your family member to interpret for you, you do have that right. But this has to be an adult. Next slide, please.
All right, Zach, I've advanced the slide. Just give it a few seconds to come through.
Okay, yeah, it's there. Okay, now there's a couple other considerations for interpreters. The first is specifically for the medical offices, which is with the length, complexity of the conversation as well as its importance. Most interactions in medical offices will actually require interpreters, according to the DOJ's guidance. And those include, for example, and this is not an all-inclusive list, but that includes billing conversations, insurance conversations, talking about your medical history, some family medical history. Then when you talk about your symptoms, and as well as diagnosis, as well as treatment plans. And, you know, since we've all been to the medical office, you can all understand how important these are. And these are important for people with disabilities. And in every one of those cases, the Department of Justice has said that those will presumptively require an interpreter because they are so complex and so important conversations for people. Now, there is one consideration that you sometimes hear about, and this is something that is especially present in certain kinds of medical care, and that is you aren't likely to require an interpreter if the treating medical professional can directly communicate with the individual in sign language. However, that person cannot serve as an interpreter for others unless licensed. And there are certain circumstances where it's probably actually required. For example, if you have someone who is conducting a cognitive speech language evaluation, that person, because needs to actually be able to communicate in the sign language in order to conduct the evaluation. Some certain forms of therapy have also been identified as such situations where it's actually preferred to have a medical professional who can directly communicate. And the rule with unless licensed, what that means is there's certain large hospitals that actually employ interpreters on the staff of the hospital, and that allows that. But if you have, for example, a nurse who can speak some language, that nurse is not allowed to interpret for the doctor unless the nurse has in fact been certified as an interpreter. And the interpreters can be provided to satisfy with the ADA requirements, can be provided either in person or through video remote interpretation. And both of those have their own requirements. Next slide, please.
All right, Zach, it should be just a minute.
Okay, I have a couple specific tips from medical offices, and these are based upon our experience from areas that we found have been specifically important for us and very successful with us. One is to make the request at writing at the time you're making your appointment, and this allows the medical office time to secure an interpreter for the appointment. The second is to go ahead, if you have an interpreter you prefer using, to provide the contact information for interpreters, provide the Virginia Department for the Deaf and Hard of Hearing directory of qualified interpreters. And one of the things I've actually been told by several medical offices is it actually costs a lot less to use an interpreter than people were anticipating. They're expecting interpreters to cost a lot more. Now, the third is that doctors' offices especially find it very important that using an interpreter assures proper care and avoids misunderstanding and communication. Finally, it's important to emphasize that effective communication will allow for quicker and smoother appointments. Next slide, please.
All right, Zach, it should be coming.
I think I can see it on this end, on-site in-person interpreter requirements.
Yeah, I can't see it. My screen seems to have frozen. But if you can,
You want to try to exit and come back in?
You know what, Zach, I'll just go ahead and take this slide. I think we're almost to the end of yours.
yeah, I'm actually done with mine with just the two slides left.
Sure,
And
I'll go ahead and run through these then, and we'll go ahead and then turn it over to Karen. And Karen, if you want to go ahead and get ready, we'll have you on deck in just a minute. So as Zach was just saying, the interpreter has to be qualified for the type of communication required. As you can imagine, some levels of communication involving medical appointments are much more sophisticated than others. We want to ensure that the communication is going to meet the needs for, in a lot of cases, some really sophisticated medical terminology and communication. Certain types of communication can require specific licenses or accreditations. I think we're going to just wait and hear just a little bit more about that in the next segment, so I won't get into that. And as Zach pointed out, sometimes we don't want family members involved because they may not be unbiased. There may be a disagreement between the person receiving the medical care and a family member about what care should be received. And certainly there's an element of privacy there. It's really hard to maintain sometimes when a family member is in the room with you. We want to make sure that this interpretation is accurate, and we want to make sure that the person communicating and both parties, in addition, are able to understand what they are hearing, and they feel that they are also being heard. And then on the screen now are the requirements for video remote interpretation. I'm not going to go into the nuts and bolts of those technical aspects, but I would like to just say as an aside that if the video remote interpretation is not as clear as the video needs to be if it does not accurately portray the type of communication that's necessary for sort of the three-dimensional communication that may be needed for American Sign Language. That's not going to be adequate as a matter of law. So these are some things that we want to make sure that we're really solid about. If somebody says, yeah, I tried video remote last time and it just didn't work for me, that may be a way to get the preferred accommodation in that situation where otherwise it may not be available. All right, now let me just see here. Excellent. We're going to go ahead and turn the mic over. Make sure we have everybody here. Karen, the floor is yours.
This is Karen. Are you reading me okay?
I can hear you, yes. Can you see the proper slide?
I can, thank you. Sorry, I was disconnected from Zoom there for just a moment, so I'm glad to be back. Again, I'm Karen Brimm, and I'm the Interpreter Services Program Manager at Virginia Department for the Deaf and Hard of Hearing. And as Stephen said earlier, our mission really across the Commonwealth is to promote accessible communication for people who are deaf, hard of hearing. There are other categories that you might hear in the community as well, such as late deafened, which is people who become deaf or hard of hearing later in life. People who are deaf blind, who have a combined loss of both vision and sight to some degree or the other. And so there's a wide variety in the considered in the deaf community. There are deaf people, deaf and hard of hearing people who don't use sign language as their primary mode of communication. They may have grown up or been accustomed to using spoken language. They may prefer written English provision of services or through some assistive technology. But today we're mostly focusing on the need for interpreter services and what that might look like. And my slides are basically from the perspective of how a person would go about obtaining an interpreter and kind of what that process might be. So go ahead, next slide, please.
Sure. Yes, I will.
Sure. So again, interpretation and translation services can be part of providing effective communication. As Zach already explained, effective communication and reasonable accommodation are both terms that are usually worked out between the individual and the entity that they're trying to engage with, whether or not that is a state or local government, whether that is an entity that's considered a public accommodation. And so the person who is requesting the accommodation needs to be clear about what it is that will work for them and try and come to a cooperation with the services provider that they're trying to engage with. But I wanted to clarify as well that there is a difference between interpretation and translation. So interpretation usually happens in real time, where there is facilitation of communication between two people who don't use the same language. And so that can often involves basically a minimum of 3 people in the room or 3 people engaging in that interaction. So you would have, in this case, a person who uses American Sign Language and a person who uses spoken English or some other spoken language, and they have an interpreter who works to facilitate communication between those 2 people. Whether that's where all the people are in the same location, which is on-site interpreting, or whether they are in separate locations, which can sometimes be called video remote interpreting. That's Stephen wrapped up the slides just a minute ago mentioning. Translation usually involves work that from static or recorded material, such as forms, documents, recorded videos, and a translation would then be created in order to be able to convey that information. That usually is not necessarily in real time, but it usually involves the source of the message being something that is reproducible, like a form or a document. Either way, interpretation and translation should be produced in a culturally tailored and linguistically appropriate way. So, for example, it's more effective usually to have a real-life interpreter providing interpretation or translation versus something that is automated. So you might notice more noticeable errors in something that is auto-generated by artificial intelligence, auto captions, for instance, then you might see generated from a person who is able to linguistically and culturally tailor that translation or interpretation of the message. Next slide, please. So my department, VDDHH, Virginia Department for the Deaf and Hard of Hearing, is responsible for coordinating interpreters and computer-assisted real-time translation, or CART, services for state agencies and the Virginia courts. So we are able to engage interpreters who have been deemed qualified to do a particular type of work and make sure that they are available to cover a particular assignment that's been requested. And so we are sort of the middleman, so to speak, on being able to provide state agencies and the courts with services that they need in order to serve the consumers that they're working with. Usually the request comes to us from the agencies or the courts. And that means that those agencies or courts have been in contact with a consumer who has expressed the need for an interpreter or for CART services. And they have expressed that need for a particular appointment on a particular day. And those agencies or the courts would then contact us to be able to obtain that interpreter. And go ahead and click one more time. I think there might be more. There we go. So again, usually a consumer who has, say, a court date, say you got a traffic ticket, that consumer who got the traffic ticket would usually not directly contact us. They would need to contact someone at the court. Usually that's the clerk of the court, in order to be able to let them know that an accommodation is needed. And then the clerk of the court would follow through with that process. The same if you were, for example, going to go to Department of Social Services appointment. You would let your caseworker or the person who's booking that appointment for you know that you need the accommodation, and then they would come and be in contact with my department in order to be able to coordinate those services. Next slide, please. So accessing interpreters in the K-12 educational settings usually involves working with the school system directly. VDDHH does not coordinate interpreters for school systems. Many times the school system will either have their own interpreters on staff, whether that's full-time, part-time, or engaged through a contract of some kind, or they might get interpreter services as needed through some kind of vendor arrangement. And that is the responsibility of the school system in order to be able to provide interpreters for both the students who are in the classrooms enrolled in those schools who might be deaf or hard of hearing and use sign language to communicate, and also any parents that may be in the school system that need to engage with teachers or administrators. The school would also be responsible for providing interpreters for those individuals as well. Generally speaking, interpreters in the school systems, the K-12 school systems, are covered under the IDEA as related service providers and considered, again, auxiliary aids in order to be able to provide access to the classroom curriculum for that student. A lot of times the interpreter is listed in an individualized education program or an IEP, and that usually is the case if a student needs some sort of additional instruction or support in order to be able to engage with a curriculum that has been adapted for that specific student. If the student is, say, on grade level or does not need the actual curriculum adapted, but does need an interpreter in order to be able to engage with that curriculum, then they might be covered under what's called a 504 plan, which again refers to a couple of those laws that Zach talked about earlier. So there are a few different ways that you would be able to justify needing an interpreter for a student in a classroom. The ADA also covers interpreting services in the K-12 setting if it's for a parent, for them to be able to engage with the school system and be interactive in the education of their child. Next slide, please. So again, the school system is responsible for providing that. That's at no cost to the family. Students with disabilities are entitled to a free and appropriate public education. And so those services, in order to be able to engage with the school system, are provided at no cost to that student or their parents. If a parent needs interpreting services, of course, they're not going to go through an IEP process. They're not a student. They would need to make sure that teachers, administrators, school counselors, or whoever the meeting scheduler might be in that circumstance, make them aware that they need sign language interpreting services in order to be able to engage in discussion about their child's education. Many times there's a disconnect, and so the parent may end up having to, each time a meeting is scheduled, remind the person that they're working with directly that they need those services in order to be able to have the meeting be held successfully. And many times this is a follow-through process, and hopefully you get cooperation from the school system, either for your student or for you yourself as a parent, in order to be able to get the accommodations that are needed in order to be able to follow through with what you need in the school system. Next slide, please. So for higher education, of course, we're talking about students who are themselves adults. And for higher education, it usually involves interacting with a student accommodation office in order to be able to ask for an accommodation. A lot of times the adult college or university student would need to complete some sort of accommodation approval process in order to be able to ensure that that is entered on their record, that all of the instructors are made aware of what accommodations are needed for that student, and that includes interpreting services. Again, that should be at no cost to the student. It's part of the process that an office of student accommodation would take care of in order to be able to, from start to finish, make sure that a reasonable accommodation is provided. Next slide, please. Oh, excuse me. One thing to note is that the National Deaf Center on Post-Secondary Outcomes is a really helpful resource in order to be able to, both from the student perspective and from the educational organization perspective, know what responsibilities are and get more information on how to adequately provide support to a student who needs sign language interpreting services. So in the community setting, which we would consider anything that's basically not court and is not K-12 education, is not higher education, those other settings are usually sort of labeled as community settings. And that can be anything from a doctor's office appointment. It could be your employment environment. It could be a meeting of a town hall or something like that. That would be, again, at no cost to the consumer. And most of the time, the accommodation is considered, you're looking for a reasonable accommodation, and you're looking at making sure that the discussion is had whether it poses an undue hardship on that organization or the business in order to be able to provide interpreting services. As Zach mentioned, usually interpreting services are a lot less expensive than a lot of public entities think that it is. And it's also very, in my experience, and again, I'm not a lawyer, but in my experience, it is rather difficult to prove that providing a sign language interpreter is an undue hardship. So that's a discussion that an employer would have to have with the employee or what have you, but generally speaking, public entities are covered entities, and they would need to go ahead and provide a sign language interpreter. Next slide. Oh, excuse me. Consumers should submit a request for a reasonable accommodation. So whether that is letting your employer know what your request for accommodation is. And again, there is a process involved there, and being able to come to a cooperative agreement on what kinds of accommodations can be provided in the workplace. Also, places like doctor's offices and organizations, they may not know that the individual needs interpreting services unless they've been clearly requested or explained. So that self-advocacy portion is very important. Sorry for the pause here. Seems like
see if there's a little bit more there. There we go.
thought maybe something was missing from the slide. I couldn't remember what it was. There are times when a sign language interpreter is not the responsibility of the entity. There are some instances where if they're strictly speaking a private organization that does not receive, say, funding from some federal source and things of that nature that Zach was talking about earlier, there are instances where certain entities are not responsible for obtaining sign language interpreting services for a particular individual. An example might be some churches, might be some private clubs where, say, a membership has to be paid in order to be able to gain admittance. And some support groups, for instance, like Alcoholics Anonymous, where it's a volunteer group that's not strictly speaking an organization, and therefore doesn't sort of meet that threshold for having to provide interpreting services. Private events like weddings and of that nature also. There is not the responsibility, say, of the hotel who's hosting the wedding or who's been picked as a venue to provide the interpreting services. It would be the responsibility of the family that is holding the wedding, for example. So sometimes people don't know how to obtain interpreter services, and so it's important for people to know kind of where they can go to get that information. And so VDDHH provides a directory of qualified interpreters that can be accessed by the public, and it's on our website. Go ahead, next slide, please. So the Virginia Quality Assurance Screening is an assessment that is provided by my department to be able to assess an interpreter's qualifications or skills, you know, to be able to handle a particular material, and they are granted levels of aptitude or assessment. And that is a state qualifying assessment that is only valid in Virginia. But is widely used here in Virginia as a quality assurance marker. There's also a directory of nationally certified interpreters who live and work in Virginia, and that is nationally certified through the Registry of Interpreters for the Deaf, which is the leading interpreter organization for ASL to English interpreters. So depending on the setting, as Zach said, for instance, in legal settings, the courts require a nationally certified interpreter to be obtained for court proceedings. And we recommend that for medical and mental health settings, certified interpreters are used as well. But in other settings, it may be appropriate or found to be adequate to have a qualified interpreter through the VQAS program instead of or in addition to a nationally certified interpreter. So it does depend. Virginia does not have a licensure system as some other states do. And so it does take a little bit of thinking to make sure that the appropriate interpreter has been selected for a particular setting or assignment. Next slide, please. And then we also, through my department, have a document that's a directory of services for people who are deaf, hard of hearing, or deafblind. And that's updated biannually and has lists of information resources of all different kinds that are either directly servicing the deaf community or deaf friendly. And that's for a wide variety of topics, including things like mental health counselors who themselves are fluent in sign language and can provide counseling services directly without the use of an interpreter. But we do also have a list of available interpreter referral agencies who do business in Virginia. All of our resources, of course, are not necessarily an endorsement. It's a listing of available resources, and it's up to the particular consumer to decide who they would like to engage in services with. But we do have that as a resource as well for people to have a way to get started in how to obtain an interpreter to provide services at their appointment. And so anybody can contact us or take a look at our website in order to be able to gain more information. That means consumers themselves can call us and ask us questions, but also employers or doctor's offices. Anyone who's not sure how interpreting works in Virginia or how to get an interpreter can give us a call or email us and ask those questions, and we can provide with the information and resources that you need. And I think that's my last slide there.
All right, thanks, Karen. I'm trying not to go too far because I don't want to jump off of your contact information without making sure that everything's on there. So I'm going to hit
there might be
advance.
two lines, I think.
All right, 1, 2.
One more. There you go.
All right.
Thank
Excellent. All right, well, thank you so much, Karen. That was really helpful. And we're going to have an opportunity for people who have questions, either of Zach or Karen specifically regarding the material that they covered. What I'm going to do, we have about 15-20 minutes remaining. I'm going to talk generally about how these same principles apply in 2 areas. The first is specifically if you need to access court services and also, as we mentioned earlier, higher education. So we have more slides than time, probably. So we may go through some of these things a little more quickly. If you see something and you have a question about it, please go ahead and feel free to start posting your questions now. That way we can focus our time and energy on things that you specifically are interested in, and we won't spend as much time on things that maybe people are not as interested in. And so we heard Karen speak a bit about the IDEA, Individuals with Disabilities Education Act. And essentially what we have when we're dealing with the IDEA is yet another way to ensure that kids with disabilities are able to receive the services that they need. Now, it is important to remember, as Karen alluded to, that not all of the same rights that you have as a minor engaged in the educational process are going to translate over exactly when you move on into the higher education system. So some of these principles that apply under IDEA don't necessarily carry over into the higher education level. I thought this was an interesting bit of information from the IDEA website, which is really goes back to what we talked about with the percentage of people in Virginia and in the United States who are people with disabilities, and that is that it is just a natural part of the human experience. And so one of my pet peeves about access is that we tend to say, when we're dealing with access issues and people with disabilities needing access to the community, we focus a lot on things like medical offices. We talk a lot about doctor's appointments. We talk a lot about school, and we sort of see these as these fundamental necessities. But in reality, what we're working for, both the Disability Law Center of Virginia and Karen's office, and really just all of us in this field, is making sure that the world is accessible as it can be. We don't want to limit people to essential things. And who gets to decide what is essential and what is not? But we certainly want to make sure it starts with education. We want to make sure that it starts with access to medical care and of course court services and things like that as well. But it is important that as we emphasize these points that we really push forward and say, that's not where we want it to end. We want to make sure that these services are available, whether somebody wants to have transportation available to a medical office or transportation available to an ice cream shop or a movie theater. And we want to make sure that when people arrive at these destinations, that they're able to get the services that they need. So I'm not trying to duplicate things. There are some things in here that talk about how you would request these services. And I think Karen covered these pretty well. So I'm going to move ahead just a little bit and really talk about higher education in the courts. And this comes down to a different part of the Americans with Disabilities Act than what Zach covered in the first section. When Zach was talking about medical offices, we're largely talking about the part of the Americans with Disabilities Act that deals with businesses that are open to the public. But when we're dealing with higher education, especially state schools, state universities, community colleges, and even private schools that accept federal funds under the Section 504 of the Rehabilitation Act, we're talking about ensuring that the places that receive these essentially federally and state funded services are able to access those services. And as Zach alluded, this is a really important distinction, because when we are dealing with Title II of the Americans with Disabilities Act, we really do want to give that preference. We have to give a lot more weight to the preference of the individual with the disability. So as Zach mentioned, when you're dealing with place of public accommodation like a medical office, they just have to ensure that the communication is effective. And the reason for that is kind of a budget, sort of a finance thing. When you're talking about Title II entities, you're talking about state and local government. You're talking about entities that really have a pretty big bank account. And so it's going to be harder for, let's just say, hypothetically, Virginia Commonwealth University to come back and say, well, we can't afford an interpreter, than maybe a small sole practitioner medical office that might be able to come in and say, look, it's going to be a financial hardship for me provide the requested accommodation at every appointment. It doesn't necessarily seem like something we would agree with, but it's a lot harder for a Virginia Commonwealth University, a UVA, Mary Washington, these higher education services, community colleges, to come in and say, we don't have the resources to make sure that you're getting everything you need. So I think we've covered the Rehab Act pretty well. I don't want to go through and rehash all of that. But what the Rehab Act does really is it takes the rights and privileges that you would have under a public college or university in Virginia, which is going to be state funded, and it brings in, well, do you accept federal funds? And so if a school accepts federal funds, namely student loans, if the school accepts student loans in terms of payments for the services that are provided, then it doesn't just mean that the classrooms have to be accessible. It doesn't just mean that the lectures have to be accessible. We're talking about everything that makes college what college is. And this goes back to my point a little while ago, that life isn't limited to classrooms and doctors' offices and court appearances. Hopefully, if that's your college experience, you might have to make some different life choices. But anyway, for most of us, when we go to college, it's a lot of different things that we enjoy. We of course are there for the academics, but the extracurricular activities, the socialization, the peer interaction, the office hours of the faculty, the social events, athletic events. Obviously, it's football season. A lot of us enjoy college sports. Making sure that people who go and want to undertake that academic and life experience that comes with higher education, all of those extracurricular activities need to be accessible as well. And so if this takes place at the school location, if this takes place off-site, if somebody has an event off-site, a formal, something like that, these same accommodations need to be put into place to make sure that the person who's engaging in the higher education experience is allowed to enjoy all of the benefits of that secondary education thing. Now, on the flip side of this, you're not entitled to everything that you had prior to college. So when we talk about the free and appropriate public education, that doesn't really transfer over to college as well. And honestly, we're seeing a lot of pushback in some areas, particularly unfortunately, with law students and taking the bar exam. All right, so you can imagine somebody goes to college, they go to law school, they have accommodations in place throughout the whole time, and then they get through high school, they go to college, maybe they're in college and they get accommodations, maybe they go to law school and they get those accommodations, and then they go sit for the bar exam and they're told, well, we're not going to give you extra time. We're not going to give you the same accommodations that you've had based on your other components of your educational process. So it's really important to reconcile the limits of the laws that we use and try to understand that they're not going to carry over quite the way that we think they do sometimes. So I have a couple of questions, and I know we said we would take questions at the end, but I don't want to miss any of the questions since they are really a big part of what we're here for. So I'm going to take the first question. I'll go ahead and take this now. Can we clarify the point about how a person should request an interpreter when they book an appointment? What if it is an emergency situation? So Rachel, I'm not sure if that question is alluding to a medical appointment. I would assume so. Is that a medical appointment question?
Yes.
Okay. Zach, do you want to address that question? It asks about requesting an interpreter when booking an appointment, and what if it's an emergency situation? And Zach, if you can unmute and answer that question, that'd be great. Otherwise, I'll take a shot.
I can't even I can't really see my screen, so I don't know if I'm
We can hear you, but we can't see you. Now we can't hear you either. All right, Zach, can you unmute yourself again? All right, Zach, go ahead and try to unmute yourself, and I'm going to take a look at a second question. And Karen, I think this question is directed toward you potentially. Are there resources to help locate a sign language interpreter for a deaf or hard of hearing person who does not speak English? And Karen, if you can unmute and address that question, that'd be great. All right, sorry for these technical exchanges. Zach, you appear to be unmuted. So can you address the interpreter when booking a medical appointment question?
Yes, with the interpreter when booking a medical appointment, that's for scheduled appointments. Now, it's much more difficult when you have like an emergency situation. And one of the reasons, and this is actually one of the things which is so good about video remote interpretation, if the medical office can meet the technology needs or at the hospital. And the reason why is because video remote interpretation is actually the most realistic way to get a interpreter in an emergency setting. But there is the exception where the other provision is, of course, the exception where that is the one situation where they do allow a entity to require a person to have a family member, or that is the one area where a public entity can have a family member interpret and not violate the ADA is in a case where it is an emergency situation. But really, unless you have a big hospital that actually has ASL interpreters on staff, or unless you have video remote interpretation, it's really, really difficult to get an interpreter immediately. And that's one of the reasons why scheduling the interpreter in advance is a really good idea, because it can take quite a while to actually get an interpreter. I know with some of the meetings we've had, it's taken an extended amount of time to get interpreters, but really video remote interpretation is the best way to actually get in the emergency setting.
All right, thank you, Zach. If you have a follow-up question on that, please go ahead. And Karen, if you can see the question that was posted to you, I put it in the chat to you as well.
This is Karen. Yeah, I apologize for that. My Zoom locked up and would not allow me to unmute myself or do anything, so I had to go out and come back in. Yeah, the question was resources to help locate a sign language interpreter for deaf or hard of hearing people who do not speak English. So you're looking at a different language pair. In that case is how we would phrase that. So if the individual used American Sign Language, but then also used, say, Spanish as their primary spoken language that they would refer to, say, for written material, or they are raised in a home where the spoken language in the home is Spanish, there are available. Most available are your trilingual interpreters. So that would be an interpreter who could work with English, Spanish, and ASL. That's one example. If it's, say, an individual who's coming from a country that does not use American Sign Language. For example, in Australia, they use a language called Auslan, and that is not the same as American Sign Language, and they might arrive here and not be able to understand ASL. They might read written English, but they don't understand ASL, and so they would need an Auslan interpreter. If they could not locate one, or say it was some other sign language, for example, from the various types of sign language used in China, or the various types of sign language that are used in other foreign countries, then sometimes what's called a certified deaf interpreter would be used. And so generally speaking, a deaf person who has grown up fluent in ASL themselves and has been trained in interpretation can work alongside an interpreter who can hear and uses ASL and English. And they together, the deaf interpreter and the interpreter who is hearing, would work together to be able to understand the foreign sign language being used by the individual. And so it would be a team effort in order to be able to communicate with that person. There isn't a go-to resource specifically in order to be able to find an interpreter who works with a foreign sign language, but there are resources to be able to locate a certified deaf interpreter. And you could always contact the DDHH, and we could either help you locate that or tell you where to go. Depending on the language pair that you're talking about. You can also contact the Registry of Interpreters for the Deaf that keeps a listing of active interpreters. And so sometimes if it's a sign language that is not often used, it might take some legwork in order to be able to locate the appropriate interpreter work with that individual.
Right. Thank you, Karen. That was very helpful and hopefully on point. Since we're down to just our last few minutes, I thought I would go ahead and take us off the screen share. It's a very small group of us here today, so anybody who wants to ask a question, let's go ahead and make sure that we're answering the questions that you have. Thank you for those of you who did ask questions, and thank you to all of you who joined us here today. With just a few minutes left, we'll go ahead and take any final thoughts. And looks like we have one more question from chat. And let me see if that's all of them. No, I think that's everything. I think we've answered all the questions in chat. So Zach, Karen, if you have any final thoughts, please feel free to jump in. Otherwise, I think we're done, and we'll call it a wrap, maybe a couple minutes early.
I would like to thank the people who attended this, and I'm sorry about the technical difficulties, but my screen completely locked up, so I don't know what went wrong there, but that's kind of an explanation for what happened.
This is Karen. I agree. Sorry for the technical difficulties, and thank you very much for the opportunity to present today, and look forward to receiving any questions that you have in the future. Please feel free to contact us.